seeing now.
Indeed, we'll break into regular transmission and bring you important news at this time. The Chief Justice Gertrude Torkornoo, now suspended, is expected to address the public via the press in the TAD. We will go there and take you there live. Perhaps we could get some live pictures from there at this time. We know that she has been going through the courts as part of efforts to bring those impeachment processes against her to a halt, albeit to no success. My understanding is that she's taken over the stage. She's taken over the microphones, ready to address the press as she speaks publicly for the first time since the impeachment processes began.
Respected citizens and honorable members of the media, today I have requested the privilege of making a statement to the nation for 4 reasons. The first reason is that the removal process that I'm involved in as Chief Justice is historic. In all of Ghana's 68-year history as an independent republic, there has never been a hearing for the removal of the Chief Justice. One would therefore have hoped that if such a process becomes necessary, it would provide good guidance and precedent for nation building. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. The second reason for making this statement is, though I'm in the process alone, its effects ripple far beyond me as a person. This process will affect how all Superior Court justices and future Chief Justices may be removed from office. It also affects commissioners and heads of independent constitutional bodies set up to protect the freedom and justice of Ghanaian citizens as guaranteed under the 1992 Constitution. In building Ghana's democracy in the Fourth Republic, the framers of the Constitution identified public officials who must directly serve the citizens of Ghana without being afraid of unjustified punishment or reprisals from influential people or members of the executive or legislature. The framers of the Constitution identified that it is only when these public officials we can work without fear, control, or at the pleasure of influential people that freedom and justice will reign in Ghana. The law did not provide for the termination of their appointments by any authority. The Constitution set up grounds and processes for removing them from office under Article 146. And these grounds must reach the standard of, quote, inability to perform the functions of their office. The officials include, apart from Superior Court justices, commissioners of Traj, commissioners of NCCE, commissioners of EC, Electoral Commission, the Auditor General, and the Chairman and the Vice Chairman and members of the Public Service Commission. The third reason for this statement is that in order to address the troubling violations of the Constitution and illegality of the proceedings that have become obvious to me, that became obvious to me from the beginning of the process, I started an action in the Supreme Court. I applied for the proceedings of the committee set up by His Excellency the President to be held in public, so that in the interest of transparency and for the truth in the matters being raised to be made known to the people of Ghana. I did so because I knew that the secrecy of the proceedings for removing justices was not created in the Constitution as a cover-up for any agenda. The Constitution expects that only reasons for removing the Chief Justice and public officials as set out in Article 146 will be the reason for doing so. And especially, such reasons must affect public sensitive national interest or public order or safety. I realize that in my case, should the public be made aware of the allegations in the petition, they would realize that none of the allegations made border even remotely on matters of national interest or matters of public order or safety, or anything that indicates that I'm unable to perform the functions of my office. An example is an allegation that I failed to retire accountable interest of $14,000 when I traveled. When I did retire that accountable interest 2 days after I returned from my journey, I was given $14,000. I could only spend $4,400, and I returned $9,600 2 days after I returned from Ghana, from my journey. And so I knew that it was necessary that the issues being thrown around as petitions against me needed to get into the public space. I swore to a supplementary affidavit alerting the Supreme Court also of human rights violations that I had started encountering when I went to the Article 146 hearings. However, the members of the Supreme Court that heard the application refused my application for the hearing in open, and they also struck out the supplementary affidavit at the request of the Attorney General. I have decided to make this statement today because the violations have not stopped. Indeed, they have escalated beyond anything I could have imagined as possible in justice delivery. These violations include the committee's refusal, in breach of the rules of natural justice, to recognize my lawyer on the first day of proceedings, simply because I was not personally present with him. And they went ahead to make arrangements for the hearing without involving my lawyer while he was sitting in front of them. The committee has also failed to indicate the specific charges that I'm supposed to be defending myself against in order to allow me to adequately prepare a defense to the charges. The committee has gone on to permit two of the petitioners, Mr. Daniel Ofori and Shining Stars, not to testify at all or present what case they brought to them at the hearing. The committee has refused to allow me to go into the hearing with any family member. Before you enter, there's a thorough search of my body and my handbag in violation of protocols and courtesies extended to any Chief Justice, which protocols and courtesies are honored in the name of the nation, both in Ghana and outside of Ghana. And then the work of the committee is being conducted in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 have been held in facilities of the Judicial Service. It is hard not to reach the conclusion that the choice of venue against the backdrop of secrecy of proceedings is intended to intimidate me and to prevent any citizen of Ghana from knowing how the proceedings are being conducted. The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the Director of Human Resource of GIHOC. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed. As we all know, when a citizen is summoned before a court or any administrative or disciplinary committee, it is the duty of the committee or court to give the citizen a copy of the complaint that they are presiding over. You cannot be summoned without a writ, a petition, or a complaint. It is also the duty of that committee or court or tribunal to give copies of all documents that have been filed with them before the hearing is started. How does anyone defend themselves without a copy of the complaint that they have been summoned to come and answer to? This Article 146 committee has refused to give me copies of the petitions that His Excellency the President gave to them. They refused to give me a copy of the prima facie determination that His Excellency the President is supposed to have given to them. They claim that they know that the President sent me copies on 27th March of the petition on 27th March 2025. And so they do not need to show me what the President gave to them. They also claim to have copies of the responses that I gave to the President, but they will not provide the petitioners with copies of my responses. The difficulty with this is, because they are the independent body charged with the duty to conduct the hearing, what I have in my hand from the President could be different from what they have. And I cannot assume that the 2 copies are the same. Indeed, no tribunal does that. No tribunal will tell you that before you came here, we know that your landlord wrote to you, so we are looking into what your landlord wrote to you about, and so that is what we will be inquiring into. They will give you what the charges are that they are supposed to be inquiring into. Second, the petition itself has not been admitted into evidence and subjected to cross-examination by me or my lawyers. In this case, because they have permitted the petitioner who has so far given evidence of whose petition we are supposed to be dealing with, Mr. Daniel Ofori. They permitted him not to testify and confirm on oath what his petition is. There is no petition on the table. There is no evidence given by him on oath. He has not authorized anyone to testify on his behalf. So what are we inquiring into? Even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, Ghana has a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commissions of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467 of our Constitution, if a committee is set up for the removal of a Chief Justice, the committee is supposed to, quote-unquote, inquire into the petition, the answer, and the prima facie case. Therefore, we are dealing with a committee of inquiry. In spite of this, on 15th May, the committee decided, without listening to my lawyer, that it will conduct the hearing not as an inquiry, but as litigation. So they rejected the use of CI 65, which was created for the regulation of inquiries, and said they will use the High Court Civil Procedure Rules, CI 47. Then they decided that each petitioner can conduct his case as he sees fit. So they don't need to present the petition to them. Then they decided that the petitioners can call public officials to confirm what they themselves have not testified to. So, ladies and gentlemen, because the proceedings are being conducted as if it is a normal litigation between the petitioners and myself, their lawyers now choose and pick which parts of the evidence that public officials present to put on the table. This is also in violation of known rules regarding proceedings of a committee of inquiry.
You're watching our live coverage of the Chief Justice's news conference happening right now. She's been touching on a number of issues, some of which we have heard already because it was contained, or they were contained in previous applications to the committee and the Supreme Court. She's talked about how essentially the entire impeachment process is skewed against her. She's talked about the illegality of the proceedings. She's talked about why there is the need for it to be a public hearing instead of a secret hearing. And in her own words, the secrecy around the removal of justices does not find itself or does not find a place in the constitution of our country. She also feels that if the public knew the truth behind the petitions, the content in the petitions, then they will know that it does not border on her inability to do her job or anything that has to do with national security. She goes on to touch on aspects of the petition that supposedly were leaked. Now, we do not have confirmation whether or not all those documents and photographs of the said petition that we have seen on social media are indeed true and or a reflection of the actual petitions the president received. But we know that she touches on one particular issue in one of those petitions. Perhaps we'll understand why that is the case a little later when we join them again. But she says, on the subject of not retiring accountable impress, remember that in that said petition that has been roaming social media, it talks about how she traveled and refused to render account for her travels. She says that she indeed retired those impress when she returned. 2 days, she says, after she returned from her trip. She was given $14,000 to expend on that trip. She returned some $4,000. We have reestablished that connection. We can take you back there now.
Every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be.
Oh, for some reason, we keep losing audio on that. But that is suspended Chief Justice Gertrude Torkornoo making her very first public appearance since impeachment processes began for her removal. This is the first time she's addressing the matter publicly, apart from, those times that we've seen her in court. This is the first public address on the matter. We've just been going over some of the things that we've heard already. Well, we could take you back there, and then when she's done, we'll have a proper conversation on the back of this. But right now, let's take a listen to Chief Justice Torkornoo.
Since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned, rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. I thank everyone who has engaged in this conversation out of concern for my safety and well-being. Let me assure everybody that I am not seeking to cling to a title or a position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice who has served the rule of law all my working life, in fact, since I was 25, it is my onerous duty and obligation to speak up concerning anything that is extremely wrong with the administration of justice in this country. This is what I do every day. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to this situation. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on. Therefore, if false claims are made against a judge or commissioner or other public office holder subject to Article 146 proceedings just to achieve a political agenda, the solution cannot be to resign or voluntarily retire out of frustration, pressure, or fear. You would only subject yourself to two cruelties: a judgment based on false claims and loss of everything you have worked for. It may well be that the efforts being made are intended to frustrate me so that I resign, so that the architects of the scheme can go back into the media and say that the wild and unfounded allegations were not defended because they were true and I had no defense to them. As Chief Justice of the nation, who has been given the privilege and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not. Finally, let me respectfully say that the current bizarre proceedings I have brought to your attention presents a twist to our nation's democratic journey that we all ignore at our own cost. My humble view is that Ghana has come too far in the 33 years of the Fourth Republic not to be concerned about the unconstitutionalities that have been designed not to affect just me personally as Chief Justice, but all judges and public officers subject to removal processes of Article 146, if this one is successfully carried out without being questioned. Behind me is every judge in the country. Behind me is every commissioner or head of an independent constitutional body in the country. If this is successful, it will be tried on anyone. I am not countering these processes for myself, but on account of the leadership burden that I carry. If the nation is willing to accept these developments in its democratic journey, it must be understood that I sounded the warning and the nation took the decision to be passive about it. I cannot share the burden of those involved in designing and implementing this enterprise of pretending to use Article 146 proceedings to remove a Chief Justice through unknown and unlawful means, by keeping quiet about the violations of law and due process. Neither can I make anyone's burden lighter by resigning or retiring, instead of proving that not even one of these wild claims in a collection of petitions is even remotely true or meets the standard required for removing a judge. Now, allow me to take a bit of your time to walk through these petitions. They have been in the public domain for some months now. They are actually available on the internet, so I'm not addressing anything that is not known in the public space. Many negative things have been said about me through public commentary on the petitions, although the petitions were responded to 7 days after I received them. And so anyone who cared to acknowledge my side of the story would have had no need to keep repeating the petitions without discussing them with the answers. And when I provided these answers, I also added with evidence to prove that each allegation was either a lie, a wrong opinion about how work is conducted in the judicial service, a wrong opinion on the work of judges, or a wrong opinion on the duties of a Chief Justice. I'll start with Mr. Daniel Ofori's petition. It is a petition with the most claims. Only 2 out of the several allegations he's making involve him personally as a court user. In one of those allegations, Mr. Daniel Ofori is urging that I should be removed as Chief Justice because I transferred a case in which he's a party from one judge in the High Court to another. That is the crime. What Mr. Ofori did not seem to know, which I stated in my answer to that allegation, is that the judge his case was transferred from had a family crisis and had to leave Ghana suddenly for an extended period. This is the only reason why cases she was handling, including Mr. Ofori's cases, were distributed to other judges to handle. In the second allegation, Mr. Ofori accuses me of transferring a case related to the first one so that to the new judge who took over his case, after a petition had been sent to me to have the 2 cases heard together. Any lawyer or registrar could have informed him that it is a policy written into the rules of court to have cases between the same parties involving the same issue to be heard by one judge, so that we don't have different decisions from 2 judges on the same matter. So there is no basis or truth to the allegation that I transferred his cases to a new judge because I had an interest in his cases. Indeed, in the year 2020, I wrote a dissenting opinion in one of Mr. Ofori's cases in the Supreme Court. He won that application because my dissenting opinion was a minority opinion of 3 judges. The other 4 judges supported his application. After this, his lawyers applied that I should not sit on his cases again because I had presided over a different case involving him in the High Court when I was in the High Court in, I think, 2010, which he had also lost. Since then, I have not sat on any matter involving the gentleman. But what is disturbing about the current Article 146 proceedings is the fact that the cases that he's complaining about in the High Court, the ones that were transferred to one judge, started from a judgment in the Supreme Court written by His Lordship Justice Poaman in favor of Daniel Ofori. How can Justice Poaman, who gave judgment in favor of Daniel Ofori as part of a panel of Supreme Court and whose opinion I dissented with, which has made me a target of Mr. Ofori's anger, preside over processes to remove me as Chief Justice because of complaints that Mr. Ofori has? I have already protested that there is a conflict of interest for Justice Poaman to chair the committee trying me or hearing me on Daniel Ofori's petitions. What Mr. Ofori's allegations seem to suggest is that a court user can attack the Chief Justice and ask for the removal of the Chief Justice if the Chief Justice does not agree with his case while sitting as a judge, or if his preferred judge is unable to hear his case. And now the judge who supports his case gets to preside over the removal process. Apart from these 2 allegations, Mr. Ofori has no interest, no personal interest in all the other allegations he's making. And he should not have been allowed to conduct a litigation against me under the disguise of an Article 146 proceeding. In 2 allegations, he's complaining that I misappropriated public funds to buy a ticket for my husband and my daughter to travel with me. In answer to this, I handed over my letter of appointment to prove that in my conditions of appointment as Chief Justice, Ghana graciously gave me 2 vacations in a year. In the Judicial Service travel policy, since 2010, the Chief Justice can never travel alone for security reasons. And the Chief Justice is always allowed to travel with a spouse or another person of their choice. So traveling on my officially given vacations with my husband on one occasion and my daughter for the second vacation is part of the official conditions of my appointment as Chief Justice. I was also not responsible for buying the tickets in question, such that I could be said to have misappropriated the value of the tickets. Indeed, if the Judicial Service was not allowed to buy the tickets for my vacation, the remedy was for the Auditor General to surcharge me to refund the money. Anyone can check out the 2023 accounts of Judicial Service and know for themselves that there is no surcharge against me or anyone for the tickets that were purchased for my vacations. Ms. Ofori seems to be alleging that I should have traveled with my police escort alone on vacation and not a family member. And this is why he wants me removed from office. And I'm being tried or held behind the walls of the Lodge. Ladies and gentlemen, the question to be asked is, why would anyone demand that I go on vacation given to me as Chief Justice with my police security, instead of going with my husband or my daughter? And how can this be a reason for subjecting a Chief Justice to a committee of inquiry? In the petition I received, Mr. Ofori also complains that my family members should not have been given per diem when they traveled with me, and I have misappropriated the per diem they were given. But anyone reading the Judicial Service travel policy will find that it provides that when the Chief Justice travels with anyone, whether police escort, another judge, secretary, or a spouse, that person is given per diem. And the rate of per diem is not set or administered by me as Chief Justice. It is regulated and administered by the Finance Directorate and the Judicial Secretary. I've already told you about the retirement of the imprest. In an arm of government where there are almost 8,000 staff that I oversee, Mr. Daniel Ofori's petition contains allegation that I transferred one member of staff to work on a different schedule, and that is why I should be removed as Chief Justice. He also alleges that I have refused to reinstate two members of staff whose appointments were terminated around 2015, 10 years ago, when I was nowhere near being Chief Justice, and whose issues are still being heard in court. He goes on to allege that I should be removed for terminating the appointment of two staff members who went through disciplinary proceedings that were initiated by reports against them before I became Chief Justice. Though it is not clear to me why Mr. Ofori should demand that the Chief Justice should be removed for transferring a member of staff or being the final authority to sign any termination letter, I handed over to His Excellency the President records covering every administrative step on these matters, supported by the due process administered by the right officers. And yet, without issuing a prima facie determination, a warrant of suspension was signed, and now I'm defending myself where there is no petition on the table. Another allegation of Mr. Ofori is that I appointed the former Judicial Secretary as Judicial Secretary when she was a judge, and so I have made her inefficient. Now, anybody who cares to know the records which I handed over to His Excellency the President was that she became Judicial Secretary in 2018. She became a judge in 2019. I was nowhere near being Chief Justice. I was appointed in June 2023. Ms. Ofori also alleges that I have appointed judges as registrars, and this has introduced inefficiency into the management of courts. Again, the records will show that the Judicial Council decided in May 2023, before I was appointed Chief Justice, that lower court judges should be appointed as registrars of the Supreme Court. So what I did was just to implement the Judicial Council's decisions. Then, Ms. Ofori alleges that a certain gentleman, not himself, but someone, who had a case in the Supreme Court in January 2024, met a different panel in May 2024, 5 months later. So I should be removed as Chief Justice. He also claims that I refused to fix an application in a case that did not involve him in Accra, which case was pending in Koforidua. So I should be removed as Chief Justice. He complains that I supervise the Judicial Secretary to administer a decision of the General Legal Council, which was taken before I became Chief Justice. So I should be removed as Chief Justice. If you read all my responses, you'll find that I provided all the records behind these decisions. Then he complains that I recommended judges to be appointed to the Supreme Court, so I should be removed as Chief Justice. Now, anyone who knows how appointments are made with recommendations from the Ghana Bar Association, the Attorney General, and the Chief Justice will know that this last complaint only shows ignorance of a very long-standing tradition. It has been the settled practice for decades that in the recommendation of justices for the superior courts, it is the Chief Justice, the Ghana Bar Association, and the Attorney General who have the privilege of making recommendations for those who are to be nominated. The recommendations can be refused or accepted by the President. I encourage anyone to read the judgment of the Supreme Court in the case of Ghana Bar Association and others versus the Attorney General, 2015-2016, to Supreme Court of Ghana Law Reports 872, when this matter was even discussed, and other academic works that discuss this practice that has been around for decades. How has it suddenly become unconstitutional or wrong conduct or incompetence for the Chief Justice to recommend to the President to consider for nomination judges who, in her view, satisfy the constitutional standard of high moral integrity? Yet, despite all the evidence provided, there is a hearing being conducted at Edu Lodge. I have taken this walk through Mr. Ofori's petition to show that the allegations have no bearing whatsoever on any sensitive national issues or public safety or order, or my inability to perform my functions as Chief Justice. They also do not have any basis in law or truth. They are just an attempt to gather a lot of complaints together, regardless of whether they are true or not, whether they are justified or not, just to have an excuse for the conduct of this inquiry that breaks all the rules of fair hearing. I'll be done soon, don't worry. There's also a petition from a gentleman called Mr. Ayamga Akogo. His complaint is that on 14th November 2024, after the Supreme Court had given a ruling which went against him, I, as presiding judge in the Supreme Court, ordered his arrest without any reason. He attached an exhibit to his petition, which was a media report from a group called the Law Platform. This media report says that after the Supreme Court panel had ruled against Mr. Akogo, he started to shout in the courtroom, and that is why he was taken out of the courtroom. Essentially, therefore, his own exhibit contradicts his claims. Mr. Akogo goes on to claim that when he applied for a copy of the day's proceedings, which were signed by all the judges that presided on his case. He did not see a record that he had been arrested, so I should be removed as Chief Justice. What is significant about this petition is that Justice Puaman sat with me as one of the judges who heard Mr. Akogo's case and was named as a witness that Mr. Akogo will call. But His Excellency the President has appointed him to chair and inquire into this petition, and he has accepted to do so. Ladies and gentlemen, Article 1273 of the Constitution indemnifies any judge against any action or suit for any act or omission by him while exercising judicial power. This provision was just last week cited as a reason for declaring a petition against a Supreme Court nominee frivolous. And yet, I'm supposed to be defending myself on the petition of Mr. Akogo for work done in the Supreme Court with 4 other judges. The last petition is from a group called Shining Stars. Searches have shown that no such group is registered in Ghana. Yet, it has petitioned against me, and they claim that during the hearing of the case of Afenyo Makin versus Attorney General and the Speaker of Parliament, when I sat as a judge, I failed to hear the side of the Speaker of Parliament before the Supreme Court made an order, so I should be removed as Chief Justice. Again, I can only point to the fact that no judge sits alone in the Supreme Court, and the court's decisions are the decisions of all the judges who sit together. So you will see that every decision I took that is complained about by Mr. Ofori, Mr. Akogo, and the group calling itself Shining Stars was done as a part of a panel of at least 5 judges that made up the Supreme Court. And all judges in the panel are indemnified by Article 1273. How tenable, if I can respectfully ask, can it be that a petition to remove the Chief Justice from office can be entertained on these grounds? Every administrative decision is supported by my constitutional obligations, and I have shown with exhibits, or I showed to His Excellency the President with exhibits, that each decision that was listed was taken after due process, and yet a warrant of suspension was issued against me without giving reasons. Interestingly, there have been some recent suggestions about rules being made to safeguard judges from frivolous attempts to remove them from office. It sounds like an attempt to assure the judiciary that after unconstitutional and illegal means have been used to remove me, conditions will be made safer for those who help with it or those who may be afraid by the current occurrences. Despite the interesting new discussions of rules for removing judges, I am convinced that it is only a matter of time for the nation's democracy to experience the bitter harvest of what I am reporting on. And if this nation descends into the kind of proceedings behind closed doors that break all the rules of adjudication or inquiry as we know them, after all the progress that we have made in the rule of law, that descent will lead us to a place where no judge, commissioner, or head of an independent constitutional body will be safe from compromise created by fear, intimidation, threats, or a desire to please. A new standard would have been set where judges comply with what influential persons want, or stand the risk of losing everything, including their career, their pensions, and their reputations, through the smear campaigns that can accompany the process. Any petition will be enough to invoke the danger of being removed by proceedings that are not supported by law and which can be shrouded behind high security walls. I am confident that in my journey as a lawyer, as a judge, and now as Chief Justice, there is no one person in this country who can look at me in the eye and accuse me of taking a bribe to decide the case. This is the personal treasure of integrity that I live with. So what if these current proceedings are being carefully staged to result in my removal as Chief Justice, even if there's no lawful justification? All I have stated shows that any such action would have been done on the basis of lies and violations of law and due process. As a career judge who has served under 4 presidents, from High Court through Court of Appeal and Supreme Court, I could never have imagined such irregularities possible if I had not personally encountered them. I am also a mother, and I am a grandmother who must hope for better than this for our country, its rule of law and its democracy. On my part, I chose to respect His Excellency the President's warrant of suspension, even though it was clear to me that it was not supported by a prima facie determination that is required by the Constitution and decisions of the Supreme Court. I have chosen to honor the process set in place to hear the petitions, but I do not choose to hide from the nation that perversion of law, rules, and due process, as we all know them, are driving the proceedings, and this renders the proceedings unconstitutional. I choose to trust that such darkness will not totally engulf this nation. May God bless our homeland, Ghana, and make our nation great and strong. Thank you very much.
That live coverage, our live coverage indeed, of the Chief Justice's very first public appearance to address the issues of impeachment against her. In a tad, we should take you back there. It would appear that questions will be asked and perhaps answers will be given. But while we do that, just a quick run over of what we've heard so far from her. In a bit, I'll also be joined by Alfredo Kanse, who will take us through what the journey has been up until now, since the impeachment processes began. But as you heard, she's tried to detail each of those petitions. Let me also say that this is the first time we're hearing a confirmation of those petitions we have seen on social media. Remember that I had told you that we have not had confirmation officially that those petitions were true, but today we've got those petitions. Let's take you live there now. Mawena is on standby. Mawena, take us through what we've been hearing so far from her.
About all of the happenings which concerns her, and she, you see her walking out right now at this particular juncture, and no questions were taken, but amongst many other things, we know that she's described largely a lot of what it is that we've seen or she's experiencing currently the 5-member committee hearing as breaches of procedure, breaches of natural justice, amongst many other things. And she makes quite a number of references to where the hearing is happening at, with specific history to the martyrs of justice that we know in this country, which happened in what many have described as the dark days of Ghana's history, amongst many other things. But just by way of a refresher, if you want to call it that, it's been an emotional address by the Chief Justice, who makes 4 arguments is the basis upon which she's decided to speak to the nation directly today. And out of all that we've been hearing her say, she has as well touched on conversations which have suggested that all of what is happening, why doesn't she decide to just walk away from it all to ensure that it all comes to an end? She's quoted quite specifically conclusions arrived at by justices of the Supreme Court in previous cases, where she makes the argument strongly that as an official of the court and as a member or a person of interest in a process as was seen currently being undertaken under Article 146, she cannot decide by herself that she's going to resign. But a bit more really this afternoon on what it is that we've been hearing her say as part of the reasons why she's decided to want to come out today and speak and address the nation. She says that it's historic, and indeed it is quite historic. In all of our 68 years history, this is the first of a time we've ever reached this particular point where a committee has been set up and the Chief Justice has become a subject of such a committee where there are hearings for her removal. Hence, it is important that she goes through with this and then address the nation. But she as well makes reference to the decision by herself and her lawyers to challenge the ongoing processes at the Supreme Court, despite the court ruling against her, and the rulings and the reason of the court has subsequently been made public. It's a 32-page reasoning by the court which has become public, where she, amongst many other things, made an argument as to why she wanted the processes or the hearing be made public. That was disagreed upon by the justices of the Supreme Court. But today, she again made the argument as to why she believes that process should be made public. And it was a reason why she says she took her time to go through the petitions brought against her by the 3 individuals, Ms. Ofori, One Ayamga, and then Shining Stars, detailing what is captured in these petitions, and also revealing, in addition, her responses to these petitions, making the case that any right-thinking member of society, having gone through these petitions and then as well these petitions as well as her responses, any right-thinking member of society can easily come to the conclusion that all of the cases that have been brought against her is nothing short of an attempt to remove her from office. In fact, she categorically, in her address, makes a case that at some point, it is beginning to look like allegations have been bandied together and to serve as a basis upon which she can just and only be removed from office as Chief Justice. But she makes quite a number of interesting revelations, which is all I'm going to say just before I hand over back to you in studio, Kemeni, that she has instructed her lawyers to begin processes to seek a review of the conclusions as was drawn by the justices of the Supreme Court in that her injunction application. We know that the substantive matter is yet to be heard, but that injunction application which she sought to have the ongoing constitutional process halted, she says she's seeking a review of that, and so we'll look forward to it. From all intent and purposes, she says she is not doing this for herself alone, but she's doing this to protect all justices of the Supreme Court and all such members of constitutionally mandated bodies whose processes for removal has been stated quite explicitly in Article 146. And so it does look like we will continue to hear a bit more from the Chief Justice, who says that what she's currently going through is nothing short of a breach of her constitutional rights, and at times she has felt violated. Mawena Egbeta from Holiday Inn, now with a new name, which we're yet to get fully wrapped up in our minds. Back to you in studio, Kemeni, where I'm sure conversations with experts will kickstart to get an understanding as to why even we're seeing the CJ address the nation in the manner that she's done. Kemeni.
Mawena, putting it all in a nutshell, therefore, as the Chief Justice Gertrude Torkornoo has just addressed the press and by extension the public for the first time since the impeachment process has begun for her removal. She's been addressing all those issues that have come in the press. Now, Alfred has joined me, and Alfred, just before I move on to Kweku and Sasari, you're going to go through some of the things that we have heard, first of all, absolutely, but also the process so far, wouldn't you?
Absolutely, and Kemeni, you are right. And also that was complemented by what Mawena said, that the Chief Justice, well, for the first time going into the details of the petitions as we got to know had been submitted, and against a reason why she was even asked to step aside for this entire process to kick in. We knew about it, but then again, we wanted to respect the law. And so we had no right to actually put it out there. She has then opened the Pandora's box, some will say. Now getting into the details of the petition herself. But the point that she makes is that she did not receive a copy of the petition submitted to the committee by the president. What she has is the copy given to her by the president, and that she requested copies of the petition that the members of the committee have, which was going to be used for the hearing against her, but she was denied.
Absolutely.
Now, fundamental question is what really informs her doubt as to why she thinks that
they will be different.
They will be different. that the petitions that the president gave to her
will be different
from the ones that the committee will be using for her hearing. That's one that really struck me. Already, she has a position about the entire process, that it has been orchestrated, and she kept using that phrase. It's been orchestrated.
Yeah, it's been
designed to ensure her removal.
Yeah.
It has nothing to do with the constitutional process. She also makes the point that the secrecy of the proceedings, as enshrined in the Constitution, it does not necessarily mean that an agenda can be pursued to remove a Chief Justice under the clothing of that secrecy of the process.
Absolutely.
And that's why she decided that she wanted everybody
let's
to
take some of let's take some of the things that we, the questions that we have at this time to the phone lines and speak to the former executive director of the GBA. Well, my understanding is we lost Kweku and Sasari over the phone. Lawyer, my understanding is you're back, and thank you so much for joining us. It's Alfred and I over here. But I have a ton of questions, but I think we should start from the point. We know what the Chief Justice says she set out to achieve with this news conference, being that, she wants the public to know what is going on. What do you think she has achieved at the end of today, at the end of that news conference?
Hello?
Hello, lawyer, can you hear us?
Hello?
We can hear you. Can you hear us?
Yes.
Indeed.
The question again?
Yes. I was asking really, what do you think she has achieved with this news conference?
Well, thank you. I must say that I'm disappointed, honestly, to say that the Chief Justice is Chief Justice of the Republic of Ghana. He is the head of the arm of government that oversees matters of justice. If she herself is taking her own case to the court of public opinion, it means he has lost confidence in the system. Worrying concern for the whole nation. I think that very, very little as a way of projecting the image as Chief Justice of the Republic of Ghana. I think that she has been pushed to what she has done by frustration and built-in adverse remarks and loss of confidence and a personal vendetta on Justice Kwama. All have coalesced into what she has done this afternoon. I think the Judicial Council must be alive to its constitutional duty of counseling the Chief Justice on how she must behave publicly. We are paying the Council of State allowances so that they can advise the Chief Justice to behave herself. Now, if the Judicial Council is found wanting in this task, I mean, there's no justification whatsoever. The Chief Justice must not be allowed to fight her own cause in the court of public opinion. She has sworn an oath to do justice to all manner of people. And she keeps saying and reminding the whole nation that the law is the law.
Well, then, but is that not to say then? Is that not to say then, lawyer, that for her to come out?
A committee has been established by the president. She must allow the process to terminate. And then she can make her own pronouncement on the final outcome. But now that she has taken the battle to the court of public opinion, what else does she expect the president to do? They to trigger off another challenge. I think, this hasn't done very well at all.
But I mean, based off what you have said, is that not to then say that perhaps she is trying to tell the people that she has tried to use the system to fight back and she hasn't won and she's turning to the people? That is why she's speaking to us today. She would have achieved that, wouldn't she?
So now, if an ordinary litigant tells the nation with the support of the Afro Barometer that the confidence of the citizens has waned totally, what would she say? So I don't think that the mere fact of the membership of Kwama should drive her to what she has done this afternoon. If Kwama is the object, it is a personal thing that she can sort it out later. Kwama shouldn't be, her problem at all. Her problem, rather, would be to assist, to cooperate with the committee into bringing this whole thing to an end. You see, the way things are going, she's knowing herself in her own bone. And I would describe it as the musings of a drowning Chief Justice. She's only musing. And I don't think that, it is. I'm speaking now for and on behalf of my own friend Gertrude. I beg her not to not to repeat what she has done. I beg her. I'm only begging her. This one is not going to do her any good, any credit whatsoever.
I see.
She has now opened herself to attack by plunging her own dagger into a case.
Very well.
No, it's not acceptable.
Very well. Lawyer, hang on for me, Alfred. Listen, we had a ton of issues that had come up out of, that news conference that we've just seen. Yeah. Lawyer Ansari has just pushed us forward. By the way, Lawyer Ansari is former executive director of the Ghana School of Law. He's just pushed us forward into that issue about that petition, the aspect of the petition where Justice Poaman sat on the same case with her.
Yeah.
The petition has been identified by Yamga Akorogo as a, in that petition as a case in point for her stated misbehavior or misconduct.
Yeah.
And she suspects that Justice Poaman would then be a witness on that case. But here he is also chair of the committee for her removal.
And she emphasized that, and he accepted to do so.
Yeah, and the president also appointed him.
But then again, she also made the point that she doesn't decide on the outcome of cases alone.
Absolutely.
Because there are a number of justices who sit on a particular case. That position that she takes, and as to whether that would also be enough basis to, as it were, then drum home a point, is one that at this time, and that's what lawyer Antasari was talking about, that she has then got into the court of public opinion because she's lost confidence in the system. But how would it end for her? I think that's the fundamental question Antasari was now getting into, as to how this will end for her. Antasari, I mean, from where you sit, how will this end for her now that she's decided to fight her case in the court of public opinion after she failed to get the Supreme Court to rule in her favor that this entire process should be made public for us all to see, on television? Hello, Mr. Azari. Hello? Fortunately, Kevin, I think we lost Ansari there. We'll try to get him back on the telephone to have a conversation. But this case has traveled a path, and rightly so. There are almost 5 suits seeking to stop the process. All of it has been thrown out, and the Supreme Court ruling on all of them. This one is what started it. The Otafo Member of Parliament, Vincent Assefuah, set the pace for that. And then when it all started, his argument was that the President violated Article 146 by consulting the Council of State before notifying the Chief Justice. Fundamental question was that how did he get to know that at that time
the president had not given
the copies of the petition to the Chief Justice? Just a day after he filed this, the Chief Justice then indicated that she has got copies of the petition against her. This was ruled out. And in fact, the former or immediate past Attorney General, Godfrey Yeboah-Dame, was a lawyer for Vincent Assefuah and still is. Now, fast forward, we see Godfrey Dame coming into the picture a lot more. Now, also was lawyer to the Chief Justice when she decided to take the matters into her own hands and then fight this matter in the court of law. Then there was a Benezose, also another citizen as well, who sought to have the Supreme Court halt their process because, in his view, the president violated Article 146 by consulting same position that Vincent Assefuah took as well. So there was that ruling. This was the 3-2 ruling, the majority ruling, if you recall, Vincent Assefuah questioning why some of the justices took the position they took. The full details of this particular ruling on this case was made available on the 21st of May, which we got into portions of it here on TV3. And then also there was one by Theodore Kofi Atakote, who made the argument that the president's discretion must conform to published regulation, and that the absence of such regulations renders the process illegal. That fundamental point that he made was flawed because the Supreme Court argued otherwise, and in fact made the point as well that the Chief Justice's suspension and the inquiry are null and void without published regulations. In fact, this matter traveled a long haul. It went, and there was a majority decision on it, throwing this particular case out. The Chief Justice herself, if you recall, when she decided to seek an interlocutory injunction on this particular process, sought a number of reliefs as well, and that includes the declaration that upon a true and proper interpretation of Article 17(1) and 2, 19(3) and 14, 1467. You recall that she mentions 1467 a number of times because she indicates that even though Article 146 details how the processes of the removal of the Chief Justice has to follow, in her view, It is more enshrined in a certain agenda
Right.
to get her off. We have someone on the line?
Absolutely. Alfred, let's bring in now lawyer Martin Pebu, who's been paying close attention to happenings in the last hour or so. Lawyer, thank you so much for your time here this afternoon. But I'll pick your initial thoughts on this matter as well. Some of the issues she's raised, again, I'll reiterate that we know, but she went in depth in some others. What are your thoughts about what you heard from her today?
So, Kamini, I'm sorry to disappoint viewers and listeners. You see, the law currently, Article 146, Clause 8, says that the proceedings should be held in camera. And so that means that we don't see what's happening. And then there's been a Supreme Court decision that we should not discuss the merits of the petitions, etc., while the case is pending. They even said the petitioner can only disclose to the media that, well, I filed a petition against so and so and so, but the petitioner shouldn't go into the details. So, unfortunately, I have to obey those rules in order not to, fall foul of the law. So we can't go into the details. You see, what Justice Torkornoo is done. Yes, a few weeks ago, I think, Kemini, fortunately, that week you moderated, or let's say you were the host of the key points that Saturday, where we have to discuss the matter of her waiver of her right to the in-camera hearing, where she said she wanted the proceedings to be broadcast. But when we finish, at the end of the day, it is clear that majority of lawyers and the majority of our society came to the conclusion that, look, 146 is clear. When they say in-camera hearing, and also based on the Frank Gertrude case and the Justice Derrick case, we should not go into the merits. The proceedings should not be broadcast live. So because of that, I cannot. I was supporting Chief Justice Torkornoo that, yes, we should. But mine was that we should first do a survey of Ghanaians. If we did a general poll and an overwhelming majority of Ghanaians said yes, then sometimes we could do so because the Constitution is made for us and not man for the Constitution.
I see.
Blah blah blah.
So lawyer, it is not true when the suspended Chief Justice tells us that secrecy of removal of justices has no place in the Constitution.
Sorry, say that again.
I'm saying that, so it is not true when she tells us that secrecy around the removal of justices is not in the Constitution or has no place in the Constitution.
Oh, is that how she put it? I didn't hear that side of it. But one thing is very clear. I joined, I don't know how many minutes I've lost, but the part I heard, that one didn't deal with that. But let's be very clear, Kemini. Article 146, Clause 8 says that the proceedings should be held in camera. And even apart from 146, okay, I'll read it, but we'll go to the Frank Gertrude case and then the, the Justice Derrick cases, which dealt with fabrication. The Justice Derrick case is the announced one, where the announced documentary was broadcast and people saw it. The Supreme Court was very clear that that should not be done. So let's go over 146 Clause 8. It says that all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard, blah, blah, blah. So the main thing, you heard the main thing, it says it shall be held in camera. And apart from that, as I mentioned earlier, there's a Frank Gertrude case where the Supreme Court held that, no, when a petition is made, the petitioner should only mention to the media that I have petitioned against so and so and so. Don't go into the content. So it's also true that though in this Chief Justice Torkornoo one, the contents were leaked. The petitions were leaked some weeks ago. We have read, but we cannot comment publicly. One thing is very clear, like I said, the chairman of the Constitution Review Commission, Professor H. Kwesi Prempeh, is in favor of making certain parts of the proceedings public that citizens should know.
Right.
But that's for the future, not in our current Constitution. So for our current Constitution, it's a closed book. Secret or in-camera hearing is in-camera hearing. But what Justice Torkornoo is doing is advocacy, paving the way for future public broadcasts, for future further disclosure of such proceedings. That's how the law is built.
I see. So, in other words, she should have been allowing the process to just, take its course against her while we prepare for a better process with an amendment of the Constitution, because she raises concerns about that as well.
Second guessing a person who is going through such a trial is a very tricky one. So what is very clear is that currently we are not allowed to do what she did. But she's doing so, as I said, what she's experiencing, you and I don't know. So I'll be very slow to second guess her. But what is clear is that no, we can't go into the merits now. That one is very clear.
I see. I seem to be rushing you because in 5 minutes we should go to the presidency. We understand that the Minister for Government Communications will be responding to the Chief Justice's news conference in the last hour. But some of the things that she's mentioned, and lawyer, for the first time, we're hearing her respond directly to the public on some of the allegations, if not all of the allegations in those petitions against her. So let's take the one by Daniel Ofori on impressed, because she talks about, her traveling with a family member, interchanging that every now and then with spouse. She says that based on her appointment letter, she is allowed to travel with a spouse, with a family member. It's unclear which one it is because she used them interchangeably. I want to hear from you, from your knowledge of the system. Is that the case?
Well, so let's say it's her defense. So once again, I'll talk about only the document I have seen, but I'm not answering directly that she has a case or not such a case. What I have seen, the policy that I have seen, shows that when the Chief Justice is on a private visit, then that one, her security detail must be with her. And then when it's an official trip, that one, it can be any other person. At least the last time I read it, that was clear to me. When it's a private visit, it must be a security detail with her. And when it is an official one, it can be any other person. That's either the security detail or a family relation. That's what I mean. And well, if I hazard the guess, it means that when it is an official trip, it is clear that usually on the official trip, they provide security. So maybe the need for extra security is less. But when it is a private visit, when she's going, they are not providing as much security as will be required. So that's why that one, there's a need for her official security to be on the trip.
I see, lawyer. I just want to read aspects of this document that stipulates, her personal travels and other official travels of justices of the Supreme Court. Now, on point 1 on personal travel, it says that the Chief Justice shall be entitled to 2 round-trip business class tickets, Accra, London, Accra, to be utilized during his or her vacation. Travel expenses, hotel accommodation, and per diem will be borne by the Judicial Service and capped at 14 days per round trip. On point 2, it says, where the Chief Justice embarks on a personal or private travel, he or she shall be accompanied by the security alone. And the travel expenses of the security, comprising air ticket, hotel accommodation, and per diem, shall be borne by the Judicial Service. And official travel, right, which is point C in this Judicial Service document, says that as per the recommendations of the Professor Dora Francisca Edu Buando Presidential Committee on Emoluments for Article 71 Office Holders 2013-2017, as it affects justices of the Supreme Court of Judicature, justices of the Supreme Court and Court of Appeals shall travel business class and shall be accommodated in a 4-star hotel. Justices of the High Court shall travel economy class and be provided with accommodation. And it goes on and on. But the reason I'm reading this is because it doesn't state clearly, all right, the familial relations supposed to travel with the occupant of the Chief Justice seat. And where I exit on this is whether or not that appointment letter that was given her will supersede the regulations of the Judicial Service.
Well, so number one, so you see, let's be clear. Where you read, you saw that when it's a private visit, it says that must be accompanied by security detail. The security detail, is that not so?
Yes.
So that is the interpretation. The way we interpret it in law is that on the private visit, it's been clear that must be accompanied by the security detail. So when it comes to the official one and it doesn't mention that must be accompanied by the official detail, that's how come by practice, if it's not the official, generally the person goes with the family, a family member. That is it. Because so the rule we use is that where the lawmaker wants to prohibit something, the lawmaker states it clearly. So you see on the private visit, the lawmaker says that go with the security. But when it comes to the official trip, it doesn't say that it must be limited to the security. Unless I didn't hear you well. Can you read the official one again?
On official travels by the Chief Justice, point 10, it says, where the Chief Justice is accompanied by the spouse or other person, he or she shall travel on the same class of air ticket as the Chief Justice and shall be paid the equivalent of half the per diem paid to the Chief Justice. On point 9, it says that the Chief Justice shall undertake unlimited official travels with either his or her spouse or other person of his or her choice in the year.
Exactly. So you see, when it is official, it's a his or a spouse or you see. So when it is official, you see that it says that spouse. Is that not what you read out?
Absolutely. Her spouse or other person.
So other person includes the daughter or the security. Any other person, that is official. So that is what I summarized for you before you read. But when it comes to the private visit, it says security, simple, full stop. There's no ambiguity.
Indeed. Lawyer, hang in there for us. Like I said, this is our live coverage of the Chief Justice Gertrude Torkornoo speaking to the Ghanaian people. In a bit, we should head for the presidency, where we are expecting the Minister for Government Communication to address the press there as well, and by extension, the nation. But Alfred is here with me, Lawyer Kwebu. Alfred, Lawyer Kwebu was also touched on areas of interest for him as far as this is concerned, and that has been the issue around imprints that were, captured in Daniel Ofori's petition to the president. She stated clearly, look, I am allowed to do this, and that is why I did. We've read aspects of the law and the regulation from the Judicial Service that allows her to do that on official travels. The question will be whether or not the committee will determine if the travel was indeed official or personal. But she mentioned during the news conference that she had gone on vacation because the Ghanaian people were gracious enough to pay for the vacation. I mean, did she give herself away? I'm not saying anything yet.
Absolutely.
I'm not saying anything yet.
But that detail also has generated a lot, especially she talks about the retiring of the accountable impress 2 days
Indeed. After
she returned, and that she spent $4,400 out of the $14,000 that was given to her.
Absolutely.
That's some detail that we didn't know until today. Right? But then again, as to whether that detail she's giving today is going to play to her favor or not, it's one question that remains unanswered. Because as Lawyer Martin Kwebu indicated, he doesn't want to follow on the path of the Chief Justice by getting into the merits of this case,
the matter.
And then the details of this petition, and then now discussing the details in public, as the Chief Justice has done now. As to whether she's lent herself now for the public scrutiny that she was seeking to avoid. Because she says she's not going to resign to make anyone's burden lighter.
Right.
She wants to go the full haul of this particular case. And so, as a result, she would rather let the public know In fact, she had 4 reasons why she did this today. In her view, that the removal process was historic, it's never happened. And so the manner in which it's being done, in her view, breaks every rule on how justices should be removed or justice should be delivered. The second point, that though she's in the process alone, the effect for far reaches beyond her. And so she would want everybody to be carried along every step of the way. And then also, in order to address the violations of the constitutional illegality regarding the entire process. This is what was captured in one of the reliefs that she was seeking in this interlocutory injunction. You take a look at this. You recall that it became a matter of conversation as to whether this hearing, although the Constitution says should be in camera, can be waived by the request of the Chief Justice. And the lawyers who commented on this indicated that it is not within her right to as it were, vary what the constitutional provision really says. She was seeking a declaration that upon a true and proper interpretation of the same articles, the right of a Chief Justice to a public hearing and all the incidents of a fair hearing may only be excluded in the interest of public morality, public safety, or public order. And as a result, she wanted this to be telecast so we can all see it. She didn't succeed in that manner. And counsel, if Lawyer Martin Bebo is there with us, counsel, are you still there with us? Hello, lawyer. We will try to get yes, counsel. I was saying that even though you don't want to go on the path of discussing the merits of this case as the Chief Justice has put out today, how do you envisage this ending? Is it going to play in her favor, what she has done now to, as it were, put out this in the court of public opinion, because she says that this matter has been discussed already in the court of public opinion? The details of the petition is out there, so she would rather let her opinion also be heard beyond what she said before the committee hearing this case.
So I didn't hear the first part of the question. So you say, what's my opinion of how it will
I was
end?
asking how you see things playing out for her. Is it going to end well for her and kneel to her favor what she has done now to put this matter out in the court of public opinion, her view, her position on the petitions against her beyond what she said before the committee, which we all didn't hear until today?
Oh, yes. So, you see, it's a mixed bag. It's a mixed bag, all right? But certainly, overall, I think she gets a bit of, what do you call it? A bit of good press, all right? Overall, though it's a mixed bag, overall, she gets a bit of good press. Do you know what happens? Where she gets the good press is that one thing is clear that, look, even though we all agree that we must keep the public purse, all right, protect the public purse, etc., generally, when it comes to the money involved, the tickets especially, you would see that generally these are not large sums. So she will get sympathy, especially from a lot of people who have abused the public purse. You know, lots of public servants have abused the public purse. Lots of public servants have traveled, all right, business class, etc. You know, even the last time the president now had to give an order that ministers should not travel first class, right? And also, did they say even business class? You know, President Mama gave a directive that there should be no first class. Then people said, nowadays, very few airlines even have first class. Then there was the question whether business class is covered. Let's dig that document and you see. But one thing that's very clear that you may not get many people contesting is that by talking openly about the money, what she brings to the fore is that definitely these are small sums. Me, I'm not going into the merits. I'm not discussing this. What she has said I'm not referring to any petition. These are things that she's referred to. So she's trying indirectly to cut the sympathies of many thousands of Ghanaians who have abused the public purse. So when you have, let's say, whoever is listening and has abused the public purse, in any manner, will now be wondering that, hey, Charlie, this could have happened to me, and many have gotten away with it. So, you know that Bible saying that let he who is without sin be the first to cast the stone. And I'm telling you that people who have abused the public purse on first-class tickets, etc., will have sympathies, because then they are careful that this thing which we've done, Charlie, in the past, hey, somebody is answering for it, etc. So that side, she's cutting some favor. As I said, that is what she has said. I have not referred to any petition. I have not talked about any petition. I'm just basing this on what she has said.
Because you're very careful in not getting into the details of this petition, would you say that to the extent that the Constitution is very clear on this process being in camera, but the person who is at the center of this entire process deciding to come out publicly to talk about it, is this act of the press conference and getting into the details of this petition contemptuous from what you said?
Yes. It is clear from CJ Gertrude, right, that and the Justice Derry matter. The Supreme Court has been clear that we shouldn't discuss the merits and the contents of the petitions. Yes, that we shouldn't discuss those. The Supreme Court has been very clear. So we are not to discuss the merits and the contents of the petitions, right? So that much is very clear that what Justice Torkornoo is reading are really from the petitions. Then that's the Supreme Court has frowned on that. Yeah.
No,
yes.
So
in a number of cases.
She's in clear contempt of the process.
No, in law, we don't mention that this is in clear contempt. So just like the way we say a person is innocent until proven guilty. So it's only when it goes to court and then the court has gone into it and come to a decision, then that's when you'll be very assertive. So maybe you say it appears this is in contempt, or this may be. Yes, because once the person has not yet been found liable, we don't run ahead, because the person has a right to innocence and to proving guilty.
Okay. Now she had doubts about whether or not the details of the petition given to her by the president is the same as was given to the committee hearing the petitions against her. Will this doubt have any foundation of merit, essentially? Can it be the case ever that the president would give her different details of petitions against her, and the committee hearing the petitions would have different sets of petitions?
No, it's not likely. The president would not intentionally do so. No, it's not likely that will be done. Yeah.
I see. Counsel, I just want to piggyback off the issue of contempt, right? While we cannot state clearly as of now if she is indeed in contempt of the committee and the work that they are doing, what will her being in contempt of the committee mean for her and the entire process?
Let's further clarify. The committee is not a court of law, all right? So it's not in contempt of the committee. And let's be very clear. What you're saying is that it's rather a violation of the rules as mentioned in Article 146, Clause 8, and as clarified by the Supreme Court in the Justice Derry matter. So, yes, I think when I was answering to Mr. Okanse, I missed that. So, Mr. Okanse, actually, to the extent that the committee is not a court of law, we cannot say that it's in contempt of the committee. Yes, we can't say so, but rather,
you know, we could say that
it's a
she's in violation of the rules.
Yes, it's a violation of Article 146, this is Clause 8, and also as further explained and clarified by the Supreme Court in the Frank Gertrude case, and also in the what do you call it? In the Derry case, the Justice Paul Derry case. So what the Supreme Court said was that in the Justice Derry case, then they say yes, you may file.
Very well.
You may file that this is a violation, and then they also even mentioned that in that case the rules of court should also come out specifically. They should make more clearer rules.
I see.
Right, on the punishment, what would be done to such persons. Yes.
Who violates the regulations. But counsel, how about you hang in there for me? Because I do want to talk about the issue she raised on Shining Stars. She said this group does not even exist, but the presidency accepted their petition. And I want to find out from you, I mean, the possibility of something as important as this falling through the cracks, and what it means for the petition presented by the Shining Stars people, whether or not it could even be taken seriously at all, if indeed it is true that this group does not exist. But also more importantly, really, after she has done this, can and should the process continue? I'll come back to you with that. Let's head for the presidency now. If you've been watching us since the beginning of our coverage, you may have heard me say at some point that we'll go to the presidency, where we expect the Minister for Government Communications to address the press and by extension the nation on, we suspect it will be on some of the things that we have heard so far from the suspended Chief Justice. But how about we go and learn actually what it could be about? Our presidential affairs correspondent, Komla Kluche, joining us live from the Jubilee House. Komla, talk to us. What will this news conference be about? Do you know yet?
Well, it's quite clear. It's a direct response to the suspended Chief Justice Gertrude Torkornoo. She made some specific allegations against the government regarding the process that she's going through now, most especially to the effect that she alleges that it's been skewed against her and it's been unfair. She's received threats even on her life and all. The government deems it necessary to respond to some of the specific allegations where she claims that the government is orchestrating this just to oust her. And so the spokesperson for government communication, Felix Kwachiofosu, is getting ready in the next minute or so thereabout to come and address the press on this. This, I must say, has gotten the attention of the government, and they feel that there's the need for them to respond to the claims being made by the embattled Chief Justice. All of this is to the effect that some of the claims that she has made are untrue, and that at every material time they've been very fair to her, given an opportunity to respond to the petitions, and also to the effect that the time of the responses given to her and all that will be at play. And so is the more reason why the government deems it very necessary that they will take responses from her. They will give responses to the claims that she's made.
And when are we expecting him to get behind the lectern and talk to the nation?
Yes, absolutely. It's been advertised at 4:30, but the staff of the presidency, especially in the department where he works, are seated here. The press is also ready to witness that response that officially government will be given with respect to the claims being made by the embattled Chief Justice. And
those will be a lot of claims to respond to. Kamala, keep an eye on events there. Let us know when the Minister for Government Communications.
Okay, so the minister just walks in now.
Absolutely. While we get ready to pick you live, I'll jump on now and hear from Lawyer Martin Kpebu just before the minister begins to talk. Lawyer, I was asking the issue about, and I expect the Minister for Government Communication to respond to that. But Could something of this nature fall, in between the cracks that this non-existent group, as per what, the Chief Justice has told us, was able to petition, and a petition is being held against the Chief Justice?
So that one, it goes to the merits. What they stated, whether it exists, it doesn't exist, that goes squarely to the merits of a case or of the case. So if we attempt to answer, then we'll be falling foul of the very injunction as mentioned, that in the Derry case, the Supreme Court said, hey, let's not do such a thing.
Lawyer, how about we go and get some answers that we cannot give here at the moment? And you hang in there, pay attention to what we hear from the presidency. Okay. Yes, Phyllis Kwachiofosu, Minister for Government Communication.
Okay.
Let's take a listen to the minister. Well, my understanding is that the minister is not ready. At this time, he's still checking his positioning on the lectern. So, lawyer, perhaps while you're still here with us, I was asking whether or not, and you see, you are worried about getting into the merit of the case. Here is the Minister of Government Communication going to respond already to the accusations being made by the Chief Justice. Wrong move?
No, because, so you remember I mentioned earlier that with what the Chief Justice has done, a lot of it goes or speaks in the direction of advocacy for change. So when the government responds, it will further, bring to the fore the issue of making parts of the petitions and the processes disclosable to the public. Because one thing is very clear, going forward into our future, we cannot continue to have...
Counsel, I'm afraid I'm going to have to cut in again because the minister is ready and he's addressing the nation.
Okay. All right.
Engagement that Her Ladyship, the Chief Justice, just had, which bordered on the petitions brought against her and the deliberations of the committee tasked to look into the matter. Ordinarily, if the matters were left to the content of the petition and the processes being undertaken by the committee, we will not have cause to comment because those are matters beyond the view of the president or the government. But a number of things were said at the media engagement that, if left uncorrected, could create an erroneous impression and project government in a very unfair, unjust, unwarranted light. To begin with, we respect the right of Her Ladyship, the Chief Justice, to express any view that she holds about the matter in question, to the extent that it is consistent with the rules, because the Constitution makes it clear what the processes are in determining a matter of the sort that we are engaged with. The Constitution requires confidentiality on the part of all parties. It is the reason why the presidency, on behalf of His Excellency the President, has refrained from commentary on the matter beyond stating what the President has done in compliance with the Constitution. So it would have been desirable that that constitutional provision was respected by Her Ladyship, the Chief Justice, so that we do not have to engage in public commentary up until the time that the committee looking into the matter makes their determination. We are compelled, however, to correct certain misimpressions that were created at the briefing. To begin with, let me point out that as yet, nobody has been able to ascribe any known verifiable constitutional breach to the president in the way that he has handled this particular matter. From the very first steps in this matter, the president has kept fidelity to the Constitution and has respected the spirit and letter of the Constitution. Everything he has done has been by the book. That is why all those who have commented on the matter, including Her Ladyship the Chief Justice, have been unable to point to any specific provision under Article 146 that the President has been in breach of. Second, in terms of confidentiality, the President has acted strictly in accordance with the Constitution. At no point in time has the Presidency put out anything in any way, shape, or form that remotely resembles any of the contents of the petition. And the only communication that has gone out on this matter have been about the steps that the President has taken in accordance with the 1992 Constitution, Article 146 to be precise. 3, Her Ladyship the Chief Justice all but insinuated that there was some political agenda at play to oust her, and that this whole process is a result of same. Let me place on record, without fear of contradiction, and let me be clear that no such political agenda exists. His Excellency the President took an oath to which he was incidentally sworn by Her Ladyship the Chief Justice herself. And in that oath, he swore to abide by the 1992 Constitution. He is enjoined to act a particular way when he receives petitions of the sort that he has received. And that is all that His Excellency has done. He has had no choice in the matter. The President cannot say that he has a view about how things should be done, and therefore, if petitions have come, he will fail to act. If he did that, he himself would be in breach of the Constitution, and therefore, he has been enjoined to act as any responsible leader or President of the Republic of Ghana would be required to do, as stipulated by the 1992 Constitution. The fourth point is also that we cannot have a sacred cow mentality in the way that we handle state affairs. Every single public official, from the President to the Speaker to the Chief Justice to Supreme Court judges to ministers to all public office holders, are bound by the provisions of Ghanaian law. Indeed, it was the former Australian Prime Minister, Kevin Rudd, who once said that when you join the game, you play by the rules. So no public official is allowed to raise him or herself above the laws of Ghana. It does not matter how sensitive your position is. Once Ghanaian law dictates that certain processes be undertaken in respect of some alleged misconduct, the rules must come to play. And that is the only guiding principle that President Mahama has operated by in all of this. So any claim, any inference, any innuendo, any imputation of a political motive to the President in respect of these processes are unfounded, they are false, and cannot be allowed to stand. And I wish to place that on record. As yet, absolutely no evidence of same has been furnished in any way, shape, or form. And therefore, I am minded to strongly reject that effort. Unfortunately, Her Ladyship, the Chief Justice herself, has added to this commentary, which initially was the tone of elements of the opposition. And it is deeply regrettable that this should happen when the President has been above board and conducted himself in strict compliance with the Constitution of Ghana. The other point that I wish to also place on record is that the attempts to link the dastardly killings of some Supreme Court judges and a military officer to this case are most disingenuous. To begin with, this government and President Mahama have nothing to do with the killing of any judge. Second, there's absolutely no nexus between the petitions that have been brought and that unfortunate incident in our past. So any effort to link the two is regrettable and should not find space in this sort of discourse. It is most undesirable, it is most unacceptable. Now, the venue in question is the Edu Lodge. Yes, it is close to the Osu Castle, which used to be the former seat of government. As I speak, there are government agencies that operate there. So it is a public place. The Osu Castle is a public place. You can go there to conduct official government business. Beside it are private residences owned by Ghanaians who move freely in and out of their residence, even though they are situated very close to the Osu Castle. So the impression that a facility in the vicinity of the Osu Castle necessarily makes it intimidating or foreboding is completely misplaced. It is unfair. It is not justifiable. Now, Edu Lodge is a state facility which is often used to house high-ranking officials who visit the Republic of Ghana. It belongs to the state. The decision to use that place was not that of government or President Mahama. The committee requested that they needed facilities of a certain status that could house their activities and that could facilitate a smooth running of the proceedings. And that facility was available. It is equipped with modern amenities that will facilitate the work of the committee. And the state only offered it upon the request of the committee. Let me also state that that facility is not intimidating. It is like any regular state facility where business can be conducted to the extent that it is put in the right shape. Wherever these proceedings were held, it will still be in camera, as clearly stipulated in Article 1468 of the 1992 Constitution. So that the proceedings are being held in camera is only in compliance with the Constitution. So it doesn't matter where it is held. And any security measure put in place is only intended to secure the place so that persons who are not authorized to be part of the proceedings do not come there and create any inconvenience. I believe that even if the hearings were held at the court premises, it will still be under significant security controls to ensure that only authorized persons have access to the place. So to describe Edu Lodge in the terms that Her Ladyship, the Chief Justice, did was most unfair and unjustifiable. It seeks to obscure the process and bring in unrelated matters that seek to cast some aspersion or ill motives on government for affording the committee a place to do its work. As I indicated, we have no interest in violating the Constitution by going into the merits of the case. And that is why government has refrained. Let me put it on record that government itself has had cause, indeed the president himself had cause, to lament the way in which some correspondence around this matter got into the media. You will recall that the very first sign of any leakage was the letter that the Chief Justice wrote requesting for copies of the petition. Before the letter got to the presidency, it was in the media. And you recall that in the president's response, in which he also took the opportunity to forward the petition to her, we raised that issue, that it was not acceptable. Indeed, we had cause, the president had cause then to ask his executive secretary to mark the documents that were being sent to the Chief Justice in order to guard against any leakage. So at no point has anybody leaked anything. Also, it must be noted that even the media houses that first broadcast the content of these petitions were media houses that you can say are aligned to the opposition. And they are the ones who have gone to town with this sort of thing. So to attempt to cast aspersions on the presidency is most unfortunate, and it causes what should be a smooth process leading to the determination of the merit or otherwise of the petitions that have been brought. So in summary, I would say that what has happened today is most regrettable. And as government, or as the President Mahama is committed to upholding the rule of law. We cannot have a situation where, depending on who is involved, the constitution is set aside. All Ghanaians are equal before the law. In the same way that our courts have dealt with individuals in accordance to law, if members of the judiciary themselves are alleged to be engaged in some wrongdoing, the processes laid down and spelled out by the Constitution ought to be respected. And that is exactly what has happened. I thank you very much. If there are any questions that you have, you may ask them.
So,
yes.
The embattled Chief Justice made reference to veiled threats on her life, and much as you're concerned about sticking to the sanctity of the constitutional procedure she needs to go through, you should equally be worried about this threat on her life. What's government's response to the specific issue about threats on her life?
The Chief Justice, more than anybody else, perhaps in this country, should be aware of the platform that is available to address such threats. Komla, if today somebody sends you a threat, you know exactly where to go to seek redress in the matter. And that is what I would say about it. Yes, Akusia.
One of the groups that petitioned, the Shining Stars group, the Chief Justice in her press conference indicated that her research done by her team show no traces of authenticity when it comes to that particular group, that the group has not been registered. Can you authenticate that group if we know anything about the Shining Stars?
First of all, I'm not sure whether there are provisions covering this, whether there's a requirement for authenticity, as it were. There were also individuals. How do you authenticate the individuals? What matters is that they have raised issues, and the Chief Justice was given opportunity by the President and the Council of State to provide initial responses, which then form the basis of the determination of a prima facie. The President, in consultation with the Council of State, came to the conclusion that there was a basis to proceed further. The President then, in accordance with Article 1466, I believe, set up the committee as spelled out by the Constitution and gave them the petitions to look into. The processes have been ongoing for quite some time now. So as far as the President is concerned, every law, rule, or regulation or process that has to be adhered to has been respected. So I do not know how this particular matter in any way impinges on the integrity of the process that has gone on so far. But then again, the Chief Justice has had cause, at least on 5 occasions. The Chief Justice and others, I must indicate, have had cause at least on 5 occasions to go to the Supreme Court to seek redress in the matter. And on all occasions, the Supreme Court has upheld the process as is currently underway. And so that, for me, should resolve the issue beyond any reasonable doubt. Yes, Max.
Okay, so my question is there any timeline that we're looking at for the committee to finish the work? Because in her speech, she made accusations that there's an attempt to frustrate her, there's also an attempt to intimidate her to get her to resign. And she made that point clearly and forcefully that she's not going to resign. I'm curious to know whether there's a specific timeline by which this hearing, should be done.
Max, as I've been at pains to explain all evening, the President can only proceed on the basis of law. The law spells out what can and cannot be done. The Constitution does not set a timeline, and therefore the President cannot impose a timeline. Indeed, at this moment, the matter is entirely out of the hands of the President, insofar as it is seized with the committee. The President cannot direct the committee on anything that they should or should not do. So it is only they who can determine the processes that are laid down to undertake this particular activity. And as and when they finish and make recommendations as stipulated by the 1992 Constitution, the President is bound to act in the manner that they recommend. So I am not in a position to speak to any timeline. Neither is the president. It is only the committee that can determine when sufficient time has been had to look into the matter. Yes. Is there any? Yes.
Are there any specific reasons why the hearing has not been done in camera? Because we know the Constitution says it clearly in 146.
Well, you have your question is self-explanatory. You've answered it. The Constitution says it should be done in camera, which means it should be done in secret.
Yeah.
Yes. So it has been done in secret, not so.
Yeah.
So why can there be a complaint about what the Constitution? First of all, there are two things that we must distinguish from each other. You can disagree with the constitutional provision. There are many in this our country who have criticized the use of contempt by courts to punish people who they perceive run extrajudicial commentary on cases that are pending. There are many people who have disagreed with it. Indeed, I have on occasion expressed my disagreement. But that is the law. Until the law is changed, you cannot say that you disagree and so it should not be applied. Same applies to this particular process. So whatever view you may have of it cannot stop the law from working. And that must be clearly understood. So we must separate criticism or misgivings about the law as it stands from adhering to the law. And as yet, nobody has been able to say that this particular law under Article 146 has been violated by the president. And that is a point that must be stressed to the hearing of all. So, if the law says that this process must be held in camera, the president has no choice than to act in ways that respect this. And I believe the committee is also respecting it at this. Indeed, the Constitution does not allow for commentary on the substance of the allegations. And there are those who may criticize the Chief Justice for violating same. We have not done that. And as I have indicated, I am not prepared to speak to the content of the petitions because we are not allowed to do so. And the president has acted in ways that the Constitution stipulates. So there cannot be a problem with this. That is why all those who have spoken have not been able to point to one evidence of infraction by the president in all of the things that have happened thus far.
Finally, we are getting this news that the Chief Justice and her legal team has filed a judicial review at the High Court.
She is entitled to do so, and we encourage her to avail herself of any opportunity there is to vindicate her rights. Yes.
Honorable, the suspended Chief Justice in her press briefing mentioned that she has received some call from individuals asking her to resign willingly or voluntarily to save her image. Has any government official or you yourself in any way called her to resign willingly to save her image?
Why would I do so? That will be the basis for me to place such a call. I have not. I have never spoken to the Chief Justice in my life. Second, no government official has placed such a call. If individuals in their private capacities, in their private lives believe that they have a relationship with her and want to call on her to act one or the other, it is a personal decision that she would have to take. But government or the president cannot force her or even suggest remotely that she should resign. So that must be placed on record. To be fair to her, I don't think that she said that any government official has asked her to do so. So we must also correct the records as they stand. Yes.
Oh,
yes.
The first time, the Chief Justice leaked her own response before getting to the president. The second time, she chose to hold a presser and level serious allegations against the government. Do you suspect that the Chief Justice has an ulterior motive to paint this government black?
Well, I cannot ascribe any motive to the Chief Justice except to express regrets over an act that may appear to violate the Constitution. But I don't think it would be fair to ascribe any motive. As I said, she has every right to adopt any measure she believes will aid her make her case, except that we all know that it is better to do so using laid down processes. Beyond that, I don't think that anybody can ascribe any ill motives to her. We have a responsibility to correct any misimpression created about how the president has acted. That is the responsibility that I'm discharging today. That is all that there is today. Indeed, if there had been no references to murdered judges and the venue, which is a state facility, or some political vendetta or agenda, I will not be addressing you. If it had been purely based on sentiments about the outcome of some court cases, or even the process that the committee is using, we would have no locus to wade into the matter. If the committee is minded and they have a way to engage the public, so be it. But I have only addressed you for the sole purpose of correcting what is a false impression that there's some political agenda at play, or that the venue has been chosen for purposes of intimidation and as a way of using some dastardly occurrence in the past as a psychological tool to wear anybody down. That is what we decry. We don't think that it has any place in this discourse. It is most unfair, most unjustified, most unwarranted. And that is the reason why I have been compelled to speak to you to clarify that matter. Thank you all for coming.
Phyllis Kwachi Ofosu, the Honourable Member of Parliament, is Government Communications Minister, just reacting to some issues that the suspended Chief Justice Gertrude Torkornoo has made mention of in her own news conference in the last couple of hours here. If you're watching us, we brought you that news conference live. Now the presidency has responded to some accusations that were leveled against the impeachment process against for the removal of Chief Justice Gertrude Torkornoo. The minister has made mention of the fact that in all that has been said, not a single breach of the Constitution has been identified as far as the president following the process is concerned. And he said no one has been able to ascribe any known constitutional breach to the president. On the subject of confidentiality, remember that during the Chief Justice's own news conference, she has said that she wanted the process to be public. And, we already know that she waived her rights to that secrecy as contained in the Constitution. But the Communications Minister, Felix Kwachi Ofosu, has said, listen, the committee, the president have all acted in confidence and in strict accordance with the Constitution. He also says that there is no political agenda whatsoever to oust the Chief Justice. Again, it is in response to Chief Justice Gertrude Torkornoo's accusation that this whole thing, this whole impeachment process is designed to remove her, is designed to kick her out of office, is designed so that at the end of the committee's probe or hearings, she will be kicked out of office. The Government Communications Minister has said that, listen, that cannot be the case because there is no political agenda whatsoever to oust suspended Chief Justice Gertrude Torkornoo. And I'll tell you more about what she's been saying. But for those of you who are just joining our coverage, let's take a listen to Chief Justice Torkornoo again.
About it. I cannot share the burden of those involved in designing and implementing this enterprise of pretending to use Article 146 proceedings to remove a Chief Justice through unknown and unlawful means by keeping quiet about the violations of law and due process. Neither can I make anyone's burden lighter by resigning or retiring, instead of proving that not even one of these wild claims in a collection of petitions is even remotely true or meets the standard required for removing a judge. Now, allow me to take you a bit of your time to walk through these petitions. They have been in the public domain for some months now. They are actually available on the internet. So I'm not addressing anything that is not known in the public space. Many negative things have been said about me through public commentary on the petitions, although the petitions were responded to 7 days after I received them. And so anyone who cared to acknowledge my side of the story would have had no need to keep repeating the petitions without discussing them with the answers. And when I provided these answers, I also added with evidence to prove that each allegation was either a lie, a wrong opinion about how work is conducted in the judicial service, a wrong opinion on the work of judges, or a wrong opinion on the duties of a Chief Justice. I'll start with Mr. Daniel Ofori's petition. It is a petition with the most claims. Only 2 out of the several allegations he's making involve him personally as a court user. In one of those allegations, Mr. Daniel Ofori is urging that I should be removed as Chief Justice because I transferred a case in which he's a party from one judge in the High Court to another. That is the crime. What Mr. Ofori did not seem to know, which I stated in my answer to that allegation, is that the judge his case was transferred from had a family crisis and had to leave Ghana suddenly for an extended period. This is the only reason why cases she was handling, including Mr. Ofori's cases, were distributed to other judges to handle. In the second allegation, Mr. Ofori accuses me of transferring a case related to the first one to the new judge who took over his case, after a petition had been sent to me to have the 2 cases heard together. Any lawyer or registrar could have informed him that it is a policy written into the rules of court to have cases between the same parties involving the same issue to be heard by one judge, so that we don't have different decisions from 2 judges on the same matter. So there is no basis or truth.
Well, now impeached Chief Justice Gertrude Torkornoo there, speaking to the content of the petitions against her. Now, that's something that the Government Communication Minister in his own news conference had said he will not do because the committee's work is going. Remember that we've also been told here that what had been done, speaking to the content of the petitions in the Chief Justice's opinion, was to get her story out there, but it's also been made clear by legal minds that it is against the rules that govern the impeachment process. And the Government Communication Minister made clear that he wants to stay away from that. But remember, the Chief Justice said, I want to get my story out there. He goes on to say that based on what he said already, the fact that there is no constitutional breach as far as the president's actions are concerned, the confidentiality of the process. And he goes on to say that every member of the public service, from the president to whoever, could be identified as the least person in the chain of public service, is not allowed to raise himself above the laws of Ghana. And then again, some words that he's used a lot: misplaced, regrettable, disingenuous, have to do with issues such as the process being targeted at her. In fact, he says that any claim of such are unfounded, false, and can't be allowed to stand, and that they strongly reject it. And then a big one on the venue, on Edu Lodge, which the Chief Justice, according to her, because she is the niece of Sam Akwa, the military man who was killed alongside the judges sometime in the 1980s. She lived with a military man at the time. She was there when he was moved away. And so it gives her some kind of PTSD to return to the place, and it would appear that it is a calculated attempt to intimidate her and violate her human rights. The government communications minister said, listen, it wasn't even the president's idea. You cannot say that it is the president's attempt to ensure that you are intimidated and kicked out of office. He says it's disingenuous to even link the occurrence of 1982 to what happened or what is happening now, because it was the committee's idea that they needed a good place where they could rest, but also have their hearings. And that was the place that was chosen. And it's near the Osu Castle. It's also near residential properties. And so it's unfair for the Chief Justice, now suspended Chief Justice, to claim that it is because they wanted to intimidate her. That is why they took the process to Edu Lodge. Now, there'll be more on this in subsequent broadcasts if you stay with us here, because this hasn't ended yet. We have heard from the presidency, we've heard from the Chief Justice as well. At 7 p.m., a lot more conversations will be had on this. Also join us at 10 p.m. Alfred Okanse will bring you Ghana Tonight, where he will discuss these very important happenings in the last couple of hours in our nation. I'm Kemini Amano. Thank you so much for joining our very special coverage. We'll return to regular programming now.